Black. One line appears at a time. His name was Walter. He was 69 years old. He had been widowed for 3 years, and he was in love again. Show 2 silhouettes, man and woman, warm scene. Her name was Carol. She was kind. She was funny. She made Walter feel alive again in a way he had not felt since Margaret died. Walter had 2 adult children, Kevin, 44, and Diane, 41, both married, both with children of their own. Family tree: Walter at top, Kevin and Diane below, grandchildren at bottom. Walter sat them both down on a Sunday afternoon before the wedding. He looked at his son. He looked at his daughter. And he said, "Everything I built with your mother, the house, the IRA, the savings, all of it is yours. Carol understands that. We have talked about it. You have nothing to worry about." Walter and kids at table: warm illustration, trust and love. Kevin and Diane believed him. They hugged their father. They danced at his wedding 6 weeks later. Walter died 14 months after the wedding. The warm illustration fades, single chair remains. And here is what Kevin and Diane discovered, sitting in an attorney's office 11 days after their father's funeral. $487,000. Walter's total estate appears slowly. Walter's estate was worth $487,000. The house, the IRA, the savings account, the investment account. $487,000 that Walter spent 38 years building with their mother, Margaret. New spouse name appears: Carol, legal surviving spouse. Carol was Walter's legal surviving spouse. Numbers splitting, red dramatic. And under the laws of the state of Ohio, Carol was entitled to an elective share of Walter's estate, regardless of what Walter's will said, regardless of what Walter promised his children, regardless of what Walter and Carol had talked about over dinner. The law does not care about dinner conversations. Elective share 30% to 50%, regardless of the will required by law in nearly every state. In Ohio, Carol's elective share was 1/3. 1/3 of $487,000. $487,000 divided by 3 equals $162,333. Carol's share, red. $162,000. Gone. Not to Kevin. Not to Diane. Not to Walter's grandchildren. To Carol. A woman Walter had known for 18 months. Walter's promise: everything is yours. The law's response: not quite. And Kevin and Diane, who had danced at their father's wedding, who had welcomed Carol into the family, who had believed every word Walter said on that Sunday afternoon, had no legal claim, no recourse, no appeal, no do-over. This happens to American families every single year. It does not have to happen to yours. I'm going to spend the next 28 minutes showing you exactly how this trap works. The 4 specific accounts that are most vulnerable the moment you remarry, and the 4 legal locks that protect every dollar for the children you promised it to, before the wedding, not after. 4 accounts, 4 locks, must be done before the wedding. Gold text held 4 seconds. Stay with me. The rule Walter did not know, amber header. Before I show you the 4 accounts, you need to understand one law. Because this law is the reason Walter's promise meant nothing. And it is the reason your will by itself is not enough to protect your children after a remarriage. The elective share, large gold text. In nearly every state in America, a surviving spouse has the legal right to claim a share of your estate, regardless of what your will says. Definition building on screen, simple clean text. This is called the elective share. And it exists specifically to prevent a spouse from being completely cut out of an inheritance. That is a good law when it protects a devoted spouse of 40 years. It becomes a devastating law when it protects a spouse of 14 months at the expense of children from a 30-year first marriage. Good law. Wrong situation. Same legal outcome. Here is exactly how it works. Elective share percentages, state-by-state comparison. Generally, a surviving spouse's elective share ranges from 30 to 50%, though some states start lower and provide for progressively larger shares as the duration of the marriage increases. Ohio, 1/3 of the estate. New Jersey, 1/3 of the estate. New York, the greater of $50,000 or 1/3. Florida, 30%. Texas, no elective share community property state. California, no elective share community property state. Map elective share states highlighted red, community property states highlighted gold. If you live in a community property state, California, Texas, Arizona, Nevada, Washington, the rules are different, but the risk to your children is still real. In community property states, assets acquired during the marriage are automatically owned 50-50 by both spouses, which means assets you bring into a remarriage may begin converting to marital property the moment the wedding happens. Your state determines your risk. Both systems can hurt your children. Amber warning. Now here is the second layer most people never learn about. The beneficiary designation override. Since beneficiary designations take precedence over the terms of your will, any unchanged designations will be enforced as written even if it means ceding accounts to the wrong person. Beneficiary designation your will, every time. No exceptions. Walter's IRA. He had named Margaret as the primary beneficiary when he opened the account in 2003. After Margaret died, he never updated the form. After the wedding to Carol, he still had not updated it. Walter assumed his will would control the IRA. It did not. The IRA had no living primary beneficiary. It fell into Walter's estate and became subject to Carol's elective share. One form, never updated. $162,000 redirected. Red held 3 seconds. One form, filed in 2003, never updated. $162,000 redirected. Walter's 4 accounts. Let me show you exactly what happened to each one. You now understand the law that caught Walter. Let me show you the 4 specific accounts that were unprotected and the exact lock that would have protected each one. If Walter had done it before the wedding. Account 1, the traditional IRA gold header. Walter's IRA balance at death, $247,000. This was the largest account, built over 38 years. Mostly his old 401k rollovers. $247,000 IRA largest asset gold. Walter assumed his will would direct this money to Kevin and Diane. His will said clearly, my IRA is to be divided equally between my son Kevin and my daughter Diane. The IRA administrator did not read Walter's will. The IRA administrator read the beneficiary form. Beneficiary form primary, Margaret Morrison deceased. Secondary, none listed. Primary beneficiary Margaret Morrison deceased. Secondary beneficiary none listed. Because there was no living beneficiary, the IRA fell into Walter's probate estate and became subject to Carol's elective share. Carol received 1/3, $82,300. From Walter's IRA alone, $82,300. Carol's share of IRA read. Kevin and Diane received the remaining 2/3, split equally, but they received it as an inherited IRA subject to the 10-year rule taxed as ordinary income, and their share was already reduced by $82,300. The lock 2 steps, done before the wedding. The lock for account 1. Step 1, update the beneficiary designation immediately. Name Kevin and Diane as primary beneficiaries. Equal shares, 50% each. Do this today. Log into the IRA custodian's website. Find the beneficiary section. Type the names. Save. 8 minutes. Free. 8 minutes online. Free. Saves $82,300. Step 2. Consider a standalone retirement trust. If the IRA balance is significant over $100,000, naming a properly drafted standalone retirement trust as the IRA beneficiary gives the children protected access to the funds while preventing the new spouse from having any legal claim, even if state law tries to include it in the elective share calculation. IRA arrow, standalone retirement trust arrow, Kevin and Diane protected green flow diagram. This trust must be drafted by an estate planning attorney before the wedding, not after. Before the wedding, not after. This is the only rule that matters for account 1. Walter had 3 more accounts unprotected, each one with a different vulnerability. Let me show you the second one. 1 account down, 3 more to go. And the second one, the savings account, is the one that surprises people most. Because most people think a joint account with your children is automatically protected. It is not. Account 2, the joint savings account gold header. Walter and Margaret had a joint savings account for 30 years. After Margaret died, the account transferred to Walter automatically as the surviving joint owner. Balance at the time of Walter's remarriage, $74,000. $74,000 savings account. Walter's name only now, no joint owner. Walter added Carol to the account 6 months after the wedding. He thought it was the right thing to do. They were married. She should have access to their money. That felt like love. Carol added as joint owner $74,000 both names. What it actually did legally was make Carol a joint owner with right of survivorship. When Walter died, the account transferred to Carol automatically. No probate, no will, no elective share calculation needed. Walter dies to $74,000 automatically to Carol. To Kevin and Diane receive 0 from this account, red. 100%, directly to Carol. The moment Walter died, Kevin and Diane received $0 from the savings account, not 1/3, not 1/2, 0. $74,000 0 to children because of one name added to a form, red large. Because a joint account with right of survivorship passes outside the estate entirely. It does not go through probate. It is not subject to the will. It bypasses everything Walter intended. Joint account with survivorship equals automatic transfer to survivor. Your will cannot stop it. The lock for account 2. Do not add your new spouse as joint owner of accounts you intend to leave to your children. Full stop. Never add new spouse as joint owner of accounts intended for children. Bold gold. Instead, use one of two approaches. Approach one individual account with TOD designation. Keep the savings account in your name alone. Add your children as transfer on death beneficiaries. When you die, the account transfers directly to Kevin and Diane. No probate. No will needed. No new spouse involvement. And no elective share exposure because TOD accounts pass outside the probate estate in most states. Account in Walter's name to TOD to Kevin and Diane to transfers directly at death green. Approach 2. Place the account in a revocable living trust with Kevin and Diane as beneficiaries. In most probate-only states, transferring assets to a revocable trust is sufficient to shield them from the spouse's elective share. Revocable trust funded before remarriage protected from elective share in most states. One critical rule: this must be done before the wedding. In augmented estate jurisdictions, states that calculate the elective share against a broader pool of assets, including trusts, the trust must be established and funded before the marriage begins. Not the day before, not the week before, weeks or months before. Before the marriage begins, not the day before, months before. Amber warning. 2 accounts protected. 2 more to go. The third one, the house, is the one that devastates families most. 2 accounts locked. The third account is the one that breaks families apart. Because it is the family home. The house where Kevin and Diane grew up. The house that Walter and Margaret paid off together over 30 years. The house Walter assumed was safe because he never put Carol's name on the deed. He was wrong. Account 3. The family home gold header. Walter and Margaret's house. Columbus, Ohio. 3 bedrooms. Paid off in 2021. Value at Walter's death, $312,000. House illustration, $312,000 paid off green glow, then fades to amber. Walter never added Carol to the deed. He thought that meant the house was protected. He thought, it is in my name alone. My will says it goes to Kevin and Diane. Carol has no claim. Walter's logic on screen, then red X appears through it. He was wrong. In 3 separate ways. 3 ways Walter was wrong, red header. Wrong number 1, the elective share. Ohio's elective share applies to assets in the probate estate. The house in Walter's name alone is part of his probate estate. Carol's 1/3 elective share applies to the house. 1/3 of $312,000. $312,000 divided by 3 equals $104,000. Carol's share red. $104,000. That is Carol's legal claim on the house Walter never put her name on. Never on the deed. Still entitled to $104,000. That is the elective share. Red. Wrong number 2, the homestead rights. In many states, a surviving spouse has homestead rights, the legal right to continue living in the marital home, even if the home was not left to them in the will. In Florida, homestead rights are constitutionally protected. Carol could have the right to live in the house for the rest of her life, regardless of what Walter's will said. Florida homestead rights: surviving spouse may have right to live there for life, regardless of will. Kevin and Diane could not force a sale, could not evict Carol, could not access the equity, not while Carol was alive. Wrong number 3, the dower rights. In some states, including older common law, states a surviving spouse has dower rights, a legal interest in real property owned by the deceased spouse. These rights can complicate a sale and create years of legal dispute between children and a surviving spouse. Elective share plus homestead rights plus dower rights equals 3 separate claims on one house. 3 separate legal claims on a house Carol was never on the deed for. Walter thought keeping Carol off the deed protected the house. It did not. Held 3 seconds. The lock for account 3. The lock irrevocable trust plus prenuptial agreement. Green header. Lock 1. The irrevocable trust. Transfer the family home into an irrevocable trust before the wedding. Name Kevin and Diane as beneficiaries. Allow yourself a life estate, the right to live in the home for the rest of your life. In most probate-only states, assets transferred to an irrevocable trust before the marriage are not subject to the elective share. House arrow irrevocable trust. Before wedding arrow, Carol cannot claim elective share green. This must happen before the marriage, not after. Before. Lock 2. The prenuptial agreement. A prenuptial agreement signed by both parties before the wedding can contractually limit the new spouse's elective share rights, homestead rights, and any other spousal claims on assets you intend to pass to your children. Prenuptial agreement. Both signatures legally limit spousal claims on premarital assets. A properly drafted prenuptial agreement clearly identifying which assets are intended for children from a prior marriage combined with an irrevocable trust gives the strongest possible protection for the family home. Prenuptial agreement plus irrevocable trust equals maximum protection for the family home. Walter had neither. Kevin and Diane lost $104,000 from the house alone. 3 accounts, 3 vulnerabilities, 3 locks. 1 account left, and it is the one most people never think about. 3 accounts locked. The 4th account is one you probably have and almost certainly have not thought about in the context of a new marriage. Your life insurance policy. Account 4, the life insurance policy, gold header. Walter had a life insurance policy. He took it out in 1998 when Kevin and Diane were young, when the mortgage was unpaid, when Margaret was still alive. Death benefit $200,000. Life insurance policy $200,000 issued 1998 primary beneficiary, Margaret Morrison. Primary beneficiary Margaret Morrison. Margaret died in 2021. Walter never updated the beneficiary form. Margaret deceased primary beneficiary, no update since 1998, red alert. He assumed because his will said Kevin and Diane get everything, the life insurance would follow his will. It does not. Life insurance does not follow your will. It follows the beneficiary form, always. Life insurance benefits are usually exempt from probate. That sounds like good news. But it means the life insurance passes according to the beneficiary form, not the will, and not the elective share calculation in most states. So here is what actually happened. Margaret was listed as primary beneficiary. Margaret was deceased. No secondary beneficiary was listed. The $200,000 death benefit fell into Walter's probate estate because there was no living beneficiary to receive it. And Carol's elective share applied. $200,000 to probate estate to Carol's 1/3 equals $66,666 red. $66,000 from a life insurance policy Walter took out in 1998 to protect his children. 1998 policy, meant for the children. $66,666 redirected to new spouse. 1 unchanged form. The lock for account 4. The lock update and structure the policy green header. Step 1. Update the beneficiary form immediately. Today, not this weekend. Today, call your insurance company or log into their website. Change the primary beneficiary to Kevin and Diane 50% each. Add a contingent beneficiary as well, your grandchildren, in case Kevin or Diane predeceases you. Policy arrow, primary, Kevin 50% plus Diane 50%. Arrow, contingent, grandchildren green. This single update takes 15 minutes, costs nothing, and redirects $200,000 to exactly where Walter intended it to go. Step 2. Consider an irrevocable life insurance trust. If the death benefit is large, over $250,000, placing the policy inside an irrevocable life insurance trust removes it from your estate entirely. The trust owns the policy. The death benefit pays into the trust. Kevin and Diane are the trust beneficiaries. The new spouse has 0 legal claim. The elective share does not apply. The death benefit is also income tax-free and outside the estate for tax purposes. Policy arrow, ILIT, trust arrow, Kevin and Diane, arrow 0, spousal claim, 0 estate tax green flow. Step 3, the no contest clause. When drafting or updating your will, include a no contest clause stating that any beneficiary who legally challenges the distribution of your estate forfeits their inheritance entirely. This discourages a new spouse or their children from filing legal challenges against the protections you have put in place. No contest clause, anyone who challenges the plan loses their share. Amber. 4 accounts, 4 locks. Let me show you Walter's story rewritten. You have now seen 4 accounts each with a specific vulnerability and a specific lock. Let me show you what Walter's story looks like when those 4 locks are in place. Split screen left red, Walter did nothing. Right green, Walter used 4 locks. Walter did nothing. IRA, $247,000 beneficiary form not updated since 2003. Margaret listed deceased. No secondary beneficiary. Falls into probate estate. Carol receives 1/3 $82,333. Kevin and Diane share 2/3 $164,667 combined. Savings account $74,000. Carol added as joint owner 6 months after wedding. Transfers automatically to Carol at Walter's death. Kevin and Diane receive 0. Family home, $312,000. Not in trust. No prenuptial agreement. Carol's elective share 1/3 $104,000. Kevin and Diane receive 2/3 $208,000 combined. Life insurance $200,000, beneficiary form, not updated since 1998. Margaret listed deceased. Falls into probate. Carol receives 1/3 $66,667. Kevin and Diane share 2/3 $133,333. Total to Carol building red. Total to Carol a woman Walter knew for 18 months. $82,333 from IRA. $74,000 from savings 100%. $104,000 from home. $66,667 from life insurance. Total to Carol equals $327,000. Large red held 4 seconds. $327,000. Total to Kevin and Diane building red. Total to Kevin and Diane from a father who promised them everything. $164,667 from IRA split equally. 0 from savings. $208,000 from home split equally. $133,333 from life insurance split equally. But wait, the total estate was $833,000. Walter only had $487,000. Where is the discrepancy? Estate taxes, attorney fees, probate costs, $46,000 in administrative costs, red. Probate costs. Attorney fees, estate administration, $46,000. Gone before anyone received a dollar. Kevin and Diane, $160,000 each. Walter's promise, everything is yours. Reality, 33 cents on the dollar. Kevin and Diane each received roughly $160,000 from a father who promised them everything. A father with a $487,000 estate. They received 33 cents on every dollar. Walter used the 4 locks. Right side green, same assets, different outcome. Before the wedding, IRA beneficiary form updated Kevin 50%, Diane 50%. IRA passes directly to children outside probate 0 elective share exposure. Kevin and Diane received $247,000. Split equally. Savings account kept in Walter's name alone. TOD designation Kevin 50%, Diane 50%. Transfers directly at death outside probate 0 elective share exposure. Kevin and Diane received $74,000. Split equally. Family home transferred to irrevocable trust. Prenuptial agreement signed. Carol waives elective share on premarital assets. Home passes to Kevin and Diane at Walter's death. Kevin and Diane receive $312,000. Split equally. Life insurance beneficiary updated Kevin 50%, Diane 50%. Passes directly outside probate 0 elective share exposure. Kevin and Diane received $200,000. Split equally. Total to Carol Green. Carol received the income and use of assets as specified in the prenuptial agreement. Fairly provided for, not enriched at the children's expense. Total to Kevin and Diane Green large. Total to Kevin and Diane $833,000. Minus only a modest estate settlement cost. Split equally. $416,000 each. Walter's promise kept. 100 cents on every dollar. Large green held 4 seconds. $416,000 each. Walter's promise kept. 100 cents on every dollar. Comparison center. Walter did nothing. Kevin and Diane each received $160,000. Walter used 4 locks. Kevin and Diane each received $416,000. Difference per child, $256,000. Same estate, same children. 4 legal moves before the wedding, $256,000. Per child, same estate, same children, same new spouse. 4 legal moves, made before the wedding. The only window that matters. There is one window in this entire situation that controls everything. The wedding date. Before the wedding, you have full legal authority to structure your assets however you choose. After the wedding, your new spouse has legal rights that no amount of estate planning can completely eliminate in every state. Before the wedding, you have full control. After the law gives your spouse rights, you cannot fully override. The prenuptial agreement must be signed before the wedding. The irrevocable trust must be funded before the wedding. The beneficiary forms should be updated before the wedding. The TOD designation should be in place before the wedding. 4 tasks, 4 checkboxes, before the wedding countdown. If you are already remarried and these steps were not taken, options still exist. A postnuptial agreement signed after the wedding can contractually limit spousal rights if both parties agree. AQTIP Trust, Qualified Terminable Interest Property Trust, can provide for your new spouse during their lifetime while ensuring the principal passes to your children afterward. QTIP Trust, new spouse gets income, children get principal after both protected. But these tools are more limited, more expensive, and less certain than the steps taken before the wedding. Before is easier than after. Before is cheaper than after. Before is more certain than after. Walter had 6 weeks between his engagement and his wedding. 6 weeks was enough time. He simply did not know what needed to be done. Now you know. Clean slide, dark navy gold border, 3 steps. 3 things before you close this video. 1. Save this video tonight. If you are considering remarriage or if someone you love is this video is the checklist. Save it. Share it before the wedding, not after. 2. Go to the comments right now and tell me 2 things. Are you already remarried, or is remarriage something you are considering? And approximately how much is in your IRA or primary retirement account? I read every comment. Your situation shapes the next video. 3. Think of one widowed parent or one recently divorced friend who is considering a new relationship, who has adult children from a prior marriage, who has never heard the words elective share or beneficiary designation override or prenuptial protection trust. Send them this video tonight, not to frighten them, to give them what Walter never had. Time. Walter had 6 weeks before the wedding. That was enough time. If he had known, Walter had 6 weeks before the wedding. That was enough time. Kevin and Diane dance at his wedding. They just needed someone to tell Walter before that Wednesday afternoon when he sat his children down before he said those words. Everything is yours. What needed to happen first? Now you know. Do not wait. I will see you in the next video.